Good evening. I'm Emily Krouse, Senior Director, Strategic Engagement and Development at UJA. Thank you and welcome to the next edition of UJA's Now You Know speaker series. Thank you for joining us and for supporting UJA. We really need everyone's support now more than ever as we take stock and determine both the immediate and long-term needs that will allow our community to come through this crisis. Our UJA community has really risen to the occasion so far. We have 600 volunteers making round-the-clock calls to our entire community. To date, we've made over 13,000 calls. We have over 200 volunteers purchasing and delivering groceries to those in need, and we've packed and delivered roughly 1,800 Passover food boxes. Every day, more volunteers are signing up, and we can't thank you enough. If you're interested in getting involved, please visit jewishtoronto.com. I'd like to thank our sponsors, Scotiabank. We really appreciate their willingness to stick with us, and we want them to know this relatively low-cost format ensures that even more of their generous funds are supporting the needs of our community. Before I turn it over to our speakers, I would just like to note this session is being recorded and will be emailed to all of you and available on jewishtoronto.com. We hope you will join us for the next Foundation and UJA co-hosted Now You Know speaker series event on April 22nd, discussing the stock market and what to do in these very uncertain times. Again, thank you for joining us tonight, and please join me in welcoming our moderator, Sheldon Disenhouse, who's a partner at Denton's practicing commercial leasing. Welcome, and thank you again for being with us tonight. I will now turn it over to you, Sheldon.
Thank you. Thanks, Emily. Hi, everyone. By way of background, we all realize that we're in very unprecedented times, and circumstances are changing daily, at least once daily. Various levels of government have established emergency orders. I understand the emergency orders in Ontario were extended today, and they've been extending them as required. Most of us are working remotely, and for some of us, that's a bit of a feat. We have no idea how long this will last. The markets are like a seesaw, up and down, and daily. Shopping centers are closed, airlines are shut down, restaurants are closed, and on and on. We know that there have been and will continue to be many COVID-19 related seminars and webinars available to our profession. We've put together a number of experts in different disciplines within our profession, and in the hope that we will make this evening interesting and informative, rather than preparing formal presentations, we as a group have prepared a number of questions that we hope and think will engender discussion amongst our panelists, and as a result, cover many of the legal and practical issues that we as lawyers have been facing and will continue to face as the COVID-19 crisis continues to evolve. We are hoping for a very interactive session, and also we'll be happy to do our best to answer any questions that are submitted. We have a wonderful panel. Full bios were included in the links to the program, so I won't go through them completely, but just by way of very brief introduction, Yael Bogler is a counsel at BLG, and she specializes in the area of commercial leasing and real estate law. Eric Carmona is a partner in the real estate group at Stikeman Elliott. His practice focuses on all aspects of commercial real estate and includes capital market transactions. Hartley Lefton is a partner in the financial services group at McCarthy Tetro, including the insurance and reinsurance group. Sari Springer is the office managing partner at Littler here in Toronto. Her practice focuses on both employment law as well as higher education law, dealing with universities. And as you heard, I'm a partner at Denton's Canada, and I specialize in the area of commercial leasing. A couple of housekeeping notes before we start. One, we plan to be finished by 9 o'clock. Number two, questions are encouraged, and please use the chat function. Number three, maybe most importantly for some people, the session qualifies for 1 hour substantive credit for the Law Society of Ontario CLE. And the last thing is that the discussion in the webinar should not replace specific legal advice. It should be considered on a case-by-case basis. So with the formalities out of the way, let me start with the first question. Hartley, this is going to be addressed to you, but I am hoping that a number of our other panelists will pipe in as well, as I might from time to time. So when you look at the markets today, and view, I guess, Hartley, you're looking at this primarily from a corporate perspective, what are you seeing? What are the issues? Force majeure clauses, the legal issues, like the force majeure clauses, like material and adverse changes, material adverse events. And one of the other legal concepts we hear a lot about is frustration, and how do you think that might apply here?
So you said I have until 9 o'clock?
Go ahead.
Well, thanks, Sheldon. Thanks, everyone, for joining. And of course, I hope you're all having a good Passover. Sheldon, I think that you're right. There are a lot of legal issues and legal doctrines that are really coming to play here as a result of COVID-19. We've seen a lot of people dust off their old law school textbooks for a review of concepts like frustration. And not to be too lawyerly, of course, but the answer is always it depends. And part of it will depend on what your contracts actually say. So this is a time when a lot of people, I suspect Eric and Yael would say the same thing on the real estate piece, especially leasing. A lot of people are dusting off their old agreements to see what exactly would qualify as a force majeure event or as material adverse change, usually in an M&A context or material adverse event in that same context. So what I've seen is a lot of clients asking, okay, what are my rights now? And on top of that, what happens if I try to exercise my rights? And so if you are a manufacturer and you can't get your inputs because of a force majeure event, that obviously relates to your agreement with your supplier. But what about your agreement downstream? So you're manufacturing for someone else. What does the force majeure being invoked in that original context have to do with your next context? What sorts of obligations do you have in terms of trying to actually satisfy your own customer, even if your supplier can't supply you? In the M&A context, obviously there's been a lot less of it in the last 6 weeks or so, and part of it has to do with uncertainty, part of it has to do with cash. There are a lot of participants saying, okay, well, cash is obviously challenging, but if we have a strategic deal and we can fund it with a number of shares, then the fact that our target has a lower value now, but our shares have a lower value, should still be proportionate. So if you were planning on funding something with 100 shares, the fact that your 100 shares are worth somewhat less should be roughly correlated with, or maybe roughly correlated with your purchase price. And so those kinds of deals, I think, still will go forward. There may be a bit more time as people try to evaluate what their priorities are and focus on their core businesses. But there are certainly a lot of businesses that are still looking for share deals. And go ahead, yes.
Yeah, I was just saying, I was going to ask Eric, actually, just following on what you're saying. In real estate deals, I don't think you often see force majeure clauses. I may be wrong, but what's happening in the real estate area?
Well, you'll see it in the financing context, certainly. Less so in the purchase agreements. You will see unavoidable delay clauses in leases. Yael can speak to that. Obviously, everyone in our department has had to go back and take a look, again, as Hartley said, brush up on basically these doctrines of force majeure, frustration, material adverse change, material adverse event. We sat around the table and, we basically started with, what does the contract say? It's very fact dependent. These clauses are very narrowly interpreted. What's our duty to mitigate? What's the process? There's very little Canadian case law on this. There's more American case law. We basically went to the American case law to see where kind of they ended up. It's, again, a fact-specific analysis. Again, in the financing context, if you're in the middle of a financing deal right now and there's a force majeure clause, you basically kind of open a dialogue with your lender and see if the lender's going to call on it. If you haven't yet signed your credit agreement, you exclude COVID-19 as a force majeure event or as a MAC event, because a MAC event has to be unknown at the time you entered into the contract. Well, COVID-19 is now a known event. So is the lender now willing to basically exclude COVID-19 as a force majeure event or as an MAE? You focus on severity. You focus on expanded contamination. Most lenders, and to all of those who are basically kind of lenders or act for lenders in the audience, lenders are in the business of basically loaning you an umbrella when it's sunny and asking it back when it rains. It's unlikely that you're going to get anywhere with the top 5 big banks. You know, they're pulling in their horns all over the place. We're seeing a significant reduction in credits being extended. But if you've got good sponsorship, you've got a good relationship with the bank, they may be willing to play ball with you. On the leasing side, you know, Yael, basically you can speak to it, but almost all major leases now will have unavoidable delay clauses of some nature.
Yeah, I mean, they do have those clauses of some nature, and I think, Sheldon, you'd probably agree with me, a lot of them in the context of the question of what happens to rental payments in the event of force majeure and when your business has to shut down as a result of the mandated closures. Most of the clauses are drafted in a manner that is favorable to the landlord. So even if a pandemic such as COVID is included in the force majeure clause, generally it seems to be the case that there's still an obligation to pay rent. Obviously, it's very fact specific and you have to look carefully at how the force majeure clause was drafted. But more often than not, the clauses do seem to be drafted in a way that requires you to continue to pay your rent. Another aspect where force majeure would come into play in the commercial leasing context is in terms of fixturing periods or landlord's work, and leases that are stores or offices that are still under development. How does the force majeure come into play in those situations? Sometimes they've been thought out, and you've got different delivery dates and delivery obligations and milestones that need to be met, and they might already be subject to force majeure, but again, would need to be looked at on a case-by-case basis. But if that is something that should be carefully considered.
I just want to jump in and say that for the most part, force majeure and frustration are concepts that basically live better on the page than they do in real life. We've actually gone back and checked the Canadian case law, and I think we found one force majeure event that actually got litigated in favor of the party trying to exercise it in 30 years. Again, more case law in the United States has basically kind of treated that issue, but there's very little in Canada. And you have to also think about the implication of exercising that clause. Will it trigger a termination of your contract? Is that what you want?
Right. And that's what I think a lot of tenants have missed that one when they right away start talking about frustration, because the contract's frustrated. It's over.
Exactly. Again,
just talking about the legal aspects, as a tenant, unless you really want out, you don't want to be talking about frustration.
Well, Sheldon, what I actually wanted to ask you maybe is, I've been hearing more and more about the doctrine of, not a doctrine necessarily here yet, but the concept of partial frustration, which is something that some Americans are trying to rely on American tenants with this concept of the contract is impossible to perform at this moment, but we're not treating it as terminated. It's just a suspension in time, essentially. Do you think, obviously the courts aren't fully in session at the moment, but pushing this down the line, do you think they're going to try and open up a whole new area of law, perhaps?
Potentially. I think there's going to be a lot of litigation when all this is over. A lot of interesting litigation on a lot of these issues. So they may very well. I think, and this is probably going to come up a number of times as we talk about these various issues, I think a lot of it's very much going to depend on how the parties deal with each other and whether they're being reasonable, trying to find a solution to what is a extremely difficult situation.
Just to digress ever so slightly to the employment law context. So there is a concept called frustration of contract in the employment law world as well, which essentially means the same thing as in your respective worlds, which is the employment agreement has become impossible to perform through no fault of either party. Though typically it's used when an employee has become ill and unable to perform for several years. And in that case, usually the employment agreement essentially just evaporates, and the employer then doesn't have an obligation to pay the otherwise significant severance payments to the employee. I hazard to say, though, in this particular circumstance, employers would have a hard time relying on the frustration of concept argument at this point, because there are too many options that are still available to employers to not yet terminate their employees, such as putting them on temporary layoffs or taking advantage of the Canadian wage subsidy program that's been rolled out, and those sorts of things. So while the concept theoretically exists in the employment law world, I think at this point it's far too soon for an employer to have a defensible argument and basically say the employment agreement has essentially evaporated. Too bad, so sad. Good luck at your next job.
But Sari, are you getting those questions yet?
Not yet. No, I have to say most employers at this point, and we've been bombarded the last number of weeks helping our employers navigate their workforces through this COVID crisis. Most of the questions are, how do we deal with our workforces in terms of temporarily laying them off, taking advantage of the Canada Wage Subsidy Program? How much does the CERB benefit provide, the Canada Emergency Response Benefit? So really they're trying to be as supportive to their workforces as they can possibly be at this time without necessarily just immediately cutting their ties. Everybody's trying to kind of hold the path for the moment because we really don't know what the future brings, and they'd really rather not have a bloodletting of sorts at this stage. So it's the temporary layoff that most employers are invoking at this stage, which I can talk a little bit about farther down the road, because that in and of itself is not quite so straightforward, and it's not an entitlement necessarily for every employer to invoke, but they're not raising the frustration issue at the moment.
Just wanted to mention that we have seen some of the knee-jerk letters that came from tenants asking for rent deferrals and rent abatement throughout frustration. Our analysis also initially is that it's too soon. It's too soon to be starting about frustration, and really, do you want to bring this contract to an end? But with so much, I think, of what we're all going to say, it's too early because things are just evolving. Government programs are evolving, and I imagine especially, in your area, Sari.
Yeah, literally daily, there's new legislation that's being passed. So you're right. You never know what tomorrow's going to bring in terms of more rights and entitlements for employees and assistance to employers.
Okay, I have a specific question for you, Sari, dealing with employers and employees. There are employers who provide essential services and they need to supplement their output. What's the situation in those circumstances with them mandating extra hours of work for their current workforce? Can they require employees to perform altered functions? And what's the situation in terms of hiring temporary workers? I guess a perfect example would be, the food supermarkets.
Right. No, exactly. And those are, I have to say, actually the more refreshing calls that we're having with our clients, because most of them, unfortunately, are at the other end of the spectrum, which, how do we lay off thousands of employees? But yes, certainly we have many clients that are essential service providers who are, working around the clock. And the bottom line is that by all means, certainly we can have our employees working longer hours. However, quite critically, it's important to remember the overtime provisions under the various provincial employment law statutes, and let's make sure that the employees aren't working in excess of those of the usual hours of work to invoke the overtime entitlements, because those can be quite enormous. And as well, in terms of altering job functions, we've been seeing a lot of that because there are certain portions of the workforce that are, that are more required than others. So they're asking employees to essentially re-qualify to do certain things, and that's certainly permissible, but only if the employee agrees to it, because otherwise it can be deemed to be a constructive dismissal, which means that the employee is being inappropriately mandated to perform functions that are not typically required of their regular job duties. So if the employee agrees, then by all means that's permitted. And the other thing that employers are doing, as you mentioned, are reaching out and hiring temporary employees for specific periods of time. And the best advice we give to employers in that context is to be sure that the temporary employees are being hired for a fixed term as opposed to an indefinite term, so there's some certainty as to how long they're going to be retained, and so forth. So yeah, by all means, if you need to ramp up, go for it.
Okay, on the other side of that, we have a question from one of the participants. Do you think an employee layoff in this period of time, this environment, would qualify for more termination pay than if it's done under what we might call normal circumstances?
No. So, and let me just clarify that there's a temporary layoff, which is not a termination. It's essentially a time period during which an employee is still considered part of the workforce. They're just not receiving pay, but they are still an employee and they have not been terminated. A permanent layoff, or in other words, a termination, is very different. That's when an employee is actually severed from the workforce and they're no longer considered an employee of that employer. But to answer the question, severing employment of an employee now during this COVID pandemic would not necessarily increase their entitlement. It certainly wouldn't increase their statutory minimum entitlement because that's strictly based on years of service. It theoretically could enhance their common law reasonable notice entitlement, which is the judge-made case law entitlement, which one of the factors that is considered is essentially how quickly the person is going to reemploy, but that's one of 5 factors. So while it may theoretically enhance their entitlement down the road, it won't be a significant enhancement to the otherwise common law entitlement.
Okay, great. I'm going to direct this one to Eric. COVID-19, in general terms, what has it done to real estate values and capital markets? How are the capital markets reacting? Some of it is obvious, but you probably have a better insight into the specifics.
Well, I think everyone has seen their equity kind of holdings pounded. Real estate is no different. On the resi side, there's obviously a lot of turmoil. Kind of CMHC has come out with programs and different tools to assist kind of borrowers through loan reamortization schemes, special arrangements, capitalization of interest. On the commercial side, as you said before, Sheldon, it's still a little early. The empirical evidence has shown that in March, only 5 to 10% of borrowers asked for accommodations in respect of their loans. But one of the reasons for that is the revenue and the rent had come in already for March, for the most part, right? The real question is what's going to happen on April 1, when basically kind of the loans are due then, or the rent is due then, because they've been shut down for basically most of March. So that's the big issue. From a capital markets perspective, lenders are drawing in their horns, right? Right now, almost all the lenders are focused on one thing, and that one thing is assessing their book, assessing the strength of their loans, and trying to figure out if the collateral they basically hold is sufficient to basically satisfy kind of the loan covenants or the sponsorship. Lenders look at 3 things. They look at, am I being compensated for the risk? That's reflected in the coupon, that's the interest rate. They say, number 2, am I basically secured? They look at the collateral. But the third question is, they say, if everything goes into the toilet, how am I going to get out? If you answer those 3 questions, you'll get your loan done. And the problem is everyone's failing on basically kind of questions number 2 and 3. There's no cash flow to basically figure out how, borrowers in kind of like the tougher spots, retail, hospitality, restaurant business, how they're going to get out, how they can see their way forward. Nobody knows how long kind of everyone's going to be shut down. And from a collateral perspective, we haven't yet seen cap rate kind of expansion, but it's only a matter of time until kind of the lenders focus on their loan books, figure out who they're going to treat with and who they're not going to want to treat with. So it's still a little early for that. The jury's out, but kind of the pain is going to happen in 2 weeks. You're going to basically see a lot of lenders, by that point of time, they'll have assessed their books. They're going to figure out who they're going to give accommodations to and who they won't. but they're going to focus on just a couple things. Number one, the durability of the NOI. Number two, the sponsorship. Number three, how well capitalized the asset is. If you've basically got 10 cents in the deal, the lender's not going to play ball with you. If you've got 50 cents in the deal and you've got good sponsorship, the lender's going to play ball with you.
So Hartley, where do you see this from, in terms of regulations and regulatory requirements?
Well, what I've seen, Sheldon, in the last few weeks is that the federal and to a lesser extent provincial regulators taking huge steps to address the problems that Eric identified in terms of finding ways to really keep capital and keep lending into the market. I was trying to do some rough math in my head, and there's probably about, through regulatory changes, there's probably pushing $1 trillion of new loans that the government regulatory changes have permitted. A couple $100 billion here, a couple $100 billion there, which is a lot of money, gets us to probably nearly $1 trillion. Now, the flip side of that is not just the government saying, okay, bank, you are allowed to dial down your capital ratio a little bit. The other side is, as Eric pointed out, the bank funding project with a good enough quality on the coupon, on the sponsor, on ability to get out. A banker told me once years ago, anyone can lend money. The tricky part is getting the money back. And right now, I think that's Eric's point number 3, which is now that things are really tricky, there's a lot of churn. If we put a lot of money into this project, which ordinarily we think is a good project, if we put money into this project, what are the odds that we get our money back? How much more money will they need? Are we going to be in a position where we're throwing good money after bad? This may end up with government making further changes, further changing capital ratios, further dialing down certain requirements to allow more loan money to get into the market. I mean, right now we've seen government do things like say that if you offer some kind of deferral on loan payments, on lease payments, on insurance premium payments, that won't be considered an underperforming asset, which is a huge step. There are a bunch of rainy day funds that the government has said, okay, lenders, you can access your rainy day funds. And some of those have put $300 billion into the market, a billion with a B. So there are certainly a lot of steps being taken, but the next question is, where are we going to put the money, and can we get the money back later on?
I think one of the questions is, how are those government programs, are they actually going to feed down to the ultimate consumer? It's great that the government is basically kind of, opening up all these programs and trying to push liquidity into the system. But the fact of the matter is, from where I sit, the lenders are going to start tightening up loan covenants. They're going to basically kind of, there's going to be way more reporting. They're going to ask for more capital to be injected in the process, in the project. They're going to ask for kind of better sponsorship. They're going to ask for more guarantors. So you see the government on the one hand kind of loosening the reins, and then on the other hand, they make funds available to the banks, and the banks are just going to tighten up.
It's basically, you've got a supply side and demand side. The government's doing what it can on the supply side, but the demand side is going to be a bit stickier.
Do either of you to see any government guarantees coming into this? I have no concept of what that might mean, really. But do you think that the government may start giving the banks some guarantees in order to encourage some of this lending?
This is something I've been thinking about a lot the last couple of weeks. My guess is we'll see a federal deficit this year of $200 billion, which is by any objective measure a lot of money. If the government can find a way to achieve all its policy objectives in terms of getting more money out into the market, finding more ways for loan deferrals and lease deferrals to be adopted by regulators, or by lenders rather, find more ways to keep people from being fired, from individuals losing their houses. We have 10%, 2 weeks ago we had 10% plus of the residential mortgage market in some sort of payment deferral. If they can figure a way to do that without writing more checks, I think that would be an approach that they would really be in favor of. So to your question, Sheldon, I think yes, this does end up with some sort of government guarantee. I think that would be the exception rather than the rule. But there will be a point in this process, maybe in the recovery rather than when we're still so deep in the soup. But there will be a point in this process, I suspect, where government does guarantee certain things, whether it's a piece of a loan portfolio or project by project basis for large infrastructure projects, for example. At some point, we're going to see that, is my guess.
Yeah. Okay. Fair enough. It was interesting in my world, Yael's world, that in out east in Nova Scotia, I think it was initially, and then New Brunswick, the government actually offered to guarantee to landlords the deferred rent. So at the beginning of April, and there was a time limit on this, they were encouraging landlords and tenants to enter into deferral agreements. And if they did it in the right form, then the government would guarantee the payment of that, the repayment, of that deferred rent. But it was limited. It was up to a maximum of $5,000 per month on any particular tenant. And there was a pool they put together, and I should have checked this, but it was only $5 million or $50 million. So it's going to go pretty quick. But it was interesting because it was an attempt, of the governments out there to try and help in the landlord-tenant work. And we actually thought when this came out that that might be a harbinger of what we'd see starting to roll across the country. We haven't yet. And of course, all of us who talk about government guarantees and everything else, all the other money the government's putting into all this, have to remember that we and our children and probably our grandchildren are going to be paying for it, over time. Not that it doesn't need to be done, but okay. Picking up on something that Eric mentioned before, I'm going to ask Yael. We had tenants, the big question near the end of March was, are tenants going to pay rent on April 1st? And everybody was holding their breaths for April 1st. A lot of tenants have not paid rent, some have. I suspect it's going to be a lot worse come May 1st. So what do you think that is going to happen? On what basis are tenants asking for these deferrals now? As you said earlier, force majeure, the lease provision probably requires that the tenant continue to pay rent. So legally, they have to pay the rent, or technically they have to pay the rent. What kind of arguments are they going to be making, do you think?
Well, I think, like you said, the challenge is that the contract itself doesn't really speak to what sorts of remedies they can be seeking or what kind of discussions they can have with their landlords. And I think the landlord and tenant relationship is a symbiotic one, and it's really a long-term relationship, almost more like a marriage than anything else. And I think that there's really going to be a lot more discussions between the landlords and tenants really on how to survive post COVID-19 and really looking forward to the future. And there's some tenants who are going to ask for the rent relief or the rent abatement because they can and everyone else is doing it, but they might actually be able to pay the rent. There are some tenants that genuinely, especially mom and pop, who don't have the resources, might not qualify for some of the government programs depending on how many employees they have. I think it's going to be done on a case-by-case basis to make the argument, make the case to their landlord as to why they should be getting a deferment or an abatement, and how to craft it in a way that it works for both the landlord and tenant. Obviously, being mindful of the fact that many landlords have mortgages that need to be paid, and they're not getting a break on those mortgages at this time, and it's challenging. And hopefully, there'll be more programs or different things put into place that would allow landlords to defer their own obligations if necessary. I know in Australia, as an example, there's a whole code of conduct right now in how to even conduct lease negotiations. And, for example, in Australia, you can't terminate leases right now, commercial leases, for the time being until I think we see where things start to fall and land post COVID-19, or as they start to ease the restrictions. So yes, there's no legal basis for asking for the rent abatement. Maybe a few of the major tenants or American tenants might have some clauses that protect them, but for the most part, most tenants likely don't have anything. So it's a matter of opening up those discussions with the landlords. But there's also some, I was speaking with a couple of landlord contacts over the past few days, and there's this whole concept of transparency. And you're asking for a rent reduction or a rent abatement, and the landlord says, okay, well, why? Show me your financials, open up your books to me. I need to see what's going on. What's your business plan? What are your receivables? What are your payables? What money do you owe? What have you done? How much money are you taking out of your business to pay X, Y, and Z, or to pay yourself even, depending on the size of the operation? And it's not a one-size-fits-all analysis, unfortunately. And I think that's even daunting for a lot of landlords, because it's easy to say, yes or no on a blanket. In this case, it's not. It really needs to be done on a case-by-case basis. And with landlords that have significant, portfolios across the country, that's a lot of potential tenants that need to be coming to you asking for it, and a lot of conversations that need to be had. And you might not even have the manpower to have those discussions. And I think that's going to be a challenge in the next couple of weeks, as we see, now they've been shut down for a full month at this point. Another 28 days from now, you're cutting right into the middle of May. I think there's a long process still, and it's really about looking forward to the future and which tenants will be viable, likely, which ones have tried to, pivot. I know some smaller retailers have tried to really pivot to an online business model, and some are successfully doing it. I don't know, how much revenue that in itself is generating, but they are doing it. So it'll be interesting to see how that plays out.
I agree. Eric, do you have a view on this? I certainly do have some thoughts, but.
Well, I can tell you that we're telling all of our tenant clients to be proactive, prepared, cooperative, and rational. If you're basically just asking for a blanket reduction with no basis behind the request, I'm telling you right now, it's going either right to the bottom of the pile or right to the top of the enforcement pile. But if you come to the landlord with a rational business case, you basically say, I understand you've got a mortgage to pay. How about I just pay the operating costs or the additional rent? Let's just defer the basic rent. Here's basically kind of a payment scheme. This is how long I can basically take it out until, let's amortize it until the end of the lease. But if you just come to the landlord and say, I'm not paying, it's going to fall on deaf ears.
I agree with you 100%. As we started to see these letters come in from tenants, some of them really got landlords' backs up against the wall, because some of them were coming from the large multinational type tenants, right? Who just, right away, knee-jerk reaction, we're not paying rent, want an abatement, whatever. And it has certainly changed, but I agree with what both of you said. And I don't know, I read something today and I thought about it, and I want to read it here because I think it was just well put. It was in the shopping center news from the ICSC today. And it was just two guys who have a lot of experience in the leasing world answering some questions. So one of the guys said, I believe tenants and owners will likely be wasting a lot of their time and possibly wasting a lot of their money if they're looking to the lease to address this unprecedented situation. The reality is that if one has to rely on the courts to dictate how to remedy this issue, it will be a long time before getting a judgment against the tenant, and recovering the judgment is likely going to be virtually impossible in most cases. I think the best action a landlord or tenant can take in the situation we are facing is to be transparent, which is Yael's word there, transparent with each other, be empathetic with the other party, ask for what you really need, compromise, and look forward to better times. This is a case where being right from a legal perspective may just be wrong. And I think that's what we've sort of come to as we started a month ago, looking at the leases and looking at the technical positions going to deal with the reality. Okay, I don't want to sort of spend all the time on leasing matters. Sari, is there a one-size-fits-all solution for employers that operate in multiple jurisdictions? So multiple jurisdictions, what do you advise? Or have you?
Yeah, so the answer is not really. So first of all, The law in the US from in the employment law area is dramatically different than in Canada. So in the US, they have something called at-will employment, which does not exist here. So in the US, employers can basically simply terminate employees at will with no severance obligations whatsoever. That doesn't fly in Canada. Furthermore, in Canada, for the most part, employers are provincially regulated, other than a small sector which are federally regulated, which are limited to banks, interprovincial trucking, and airlines. But that's just a small sector of the workforce. Most other employers are provincially regulated, which means that an employer needs to be educated about the provincial employment laws in each particular province in which they operate. And although there are a lot of similarities, there are certainly some differences. And so the employer needs to consider, for example, there have been different declared emergency leaves enacted in various provinces across Canada. In Ontario, for example, there are 2 declared emergency leaves, one for infectious diseases and one for simply an emergency, that employees can declare themselves on an unpaid leave of absence, which then precludes the employer from terminating them or laying them off. Not every province, though, has those leaves. Similarly, the layoff provisions in each province are somewhat different. There is the same general concept across Canada, which is that employers can't effectively temporarily lay an employee off unless that provision is provided for in an employment agreement. But that having been said, most employers are saying, we don't care, we're doing it anyway, because they'd rather take the risk of a constructive dismissal suit, which we think is not that large, rather than not temporarily laying off their employees and carrying a payroll that they just can't support. But all that having been said, even with that concept, there are different provisions in each province about how long a temporary layoff can last before it becomes a permanent layoff. Some provinces are 15 weeks, some provinces are 20, some provinces it depends on whether or not benefits are continued. And so you really need to drill down into each particular province's requirements before you say, okay, we're temporarily laying off all our employees across the country for this period of time and on that basis. Yeah. Okay, thank you. Hartley, I want to, we've talked about things like frustration and force majeure. What about insurance? Is there any insurance that's relevant to this, to these kinds of circumstances?
Yeah, a lot of businesses are looking to their business interruption insurance and trying to figure out, in fact, it's a very similar process as with force majeure, trying to figure out whether their BI policies can step in this sort of situation. Traditionally and typically, business interruption insurance policies have been for acts of God type of things. So your building collapses. There's a hailstorm and you lose all your windows. Your building is unusable. There have been obviously different interpretations in case law based on different policies, but certainly that's an area where a lot of businesses are hoping to turn, or at least reviewing, to figure out if those kinds of policies would respond.
Yeah, Al, have you dealt with business interruption insurance at all in the context of leases?
I've had some clients look into it with their insurers, and so far they've gotten negative responses and saying that they're not covered for it. Although I have heard from some that they do have specific policies from a couple of people I know that own properties, and have been told that their insurance would apply in that circumstance. But I think it's so fact specific. And also, I don't know, this is I came across, I didn't find the article, but in the case of dentists, they actually had business interruption insurance that included pandemics, and there's all this discussion that their insurer is not planning to pay it because they shut down prematurely, or they shut down out of their own volition rather than waiting for the government to mandate them to shut down. So it'll be interesting to see. It was in one of the papers last week about how they're actually trying to get their insurance because most dentists are unable to operate at this time except for emergency purposes. So I think the insurers are sort of also taking a step back and waiting to see what the government might do in that case as well, because, you know, no, I don't think anyone ever expected to pay out on such a wide-scale basis.
Right.
That's
what
go ahead. The other area I should mention is receivables insurance. The receivables insurance sometimes may kick in depending on what your policy says.
So you need to take a look at your business interruption insurance policy, because most of them are very specifically tied to where the interruption is tied to physical loss or damage. In Hartley's examples, you know, kind of a hailstorm, a flood, a fire, something like that. Those are all, those tied to physical damage, right? Coronavirus harms people. And so a lot of insurance companies are denying liability on the basis of the fact that the coronavirus does not tie into your business, and just the gateway to business interruption insurance just isn't met.
Yeah, I think
as it relates to the dentists, you know, my brother and sister-in-law are both dentists, so I've kind of stared at this for them. And the Royal College, or the College for Dentists, it was a specific pandemic rider that you could opt into or opt out of. It wasn't bundled with your ordinary insurance. And
yeah, it wasn't sure.
And yeah, and for the most part, insurance companies are taking a look at COVID-19 and saying, it's all like the flu at the end of the day, right? So for the most part, they're denying coverage.
I think there's going to be
ultimately we're always at the mercy of the words on the paper.
Yeah, there's going to be some interesting litigation.
Yeah,
I think on this. What I had heard was, generally speaking, as you were saying, it doesn't apply. After, I understand that after, and you be aware of this, after SARS, a lot of the policies clearly excluded pandemics and this kind of thing. But I think also that the advice to clients would be push on it. Like if you just ask your brokers, they're going to, in most cases, they're going to say it doesn't apply. And I think you have to drill down a little more to really be satisfied that, in fact, the business interruption insurance doesn't apply. Okay, I'm going to go back to Sari. Have you seen, and you've touched on some of this, but what have you seen that employers tend to be doing to cut down on their expenses?
Yeah, so as I mentioned before, the most common thing we're seeing are the temporary layoffs as opposed to the permanent terminations, just because employers don't want to lose their workforce permanently. They're trying to ride it out and hopefully bring them all back in the not too distant future. As I said, it carries a little bit of risk, but most employers are doing it anyway. The other things that employers are doing are cutting back salaries and benefits. So again, we need to be careful about constructive dismissal claims, because if you cut back an employee's remuneration package to any fundamental degree, they can claim a constructive dismissal. Again, who's going to do that? I would say that most employees would rather remain employed at a reduced salary than claim a constructive dismissal and then look for a new job in these times. But so employers are doing a lot of that, cutting back salaries by 10, 15%, taking away some of the fringe benefits, rolling back car allowances, those sorts of things. And as I said before, reorganizing the workforce so that there are some work sharing programs that are available that they can apply to through the federal government. Basically, you know, any sort of creative idea, I'm all ears.
Yeah. Eric, from your perspective, and Hartley may have seen some of this too, what strategies are being employed, or do you think could be employed to preserve liquidity? What do you see clients doing to try to do that?
So if you've got a line of credit out there right now, you should be tapping it. I don't know if it's a cash flow revolver or an ABL loan. If it's an ABL loan, you probably got some issues in terms of, the borrowing base. If it's a revolver, take a look at your financial covenants, see if you've met them. Don't forget, every time you draw down on your loan, you have to refresh your reps and warranties. So, before you basically ask, you got to make sure that you qualify. We're seeing a lot of borrowers speak to lenders about kind of a type of loan that gives the lender some comfort. It's called a flex loan, or adding flex provisions to a loan, where a lender has the ability to increase the coupon by up to 20 beeps or 25 beeps in the event they think they're not making enough money on the deal, enough return on the deal. You should be basically thinking about what kind of additional sponsorship you can add, what kind of additional equity you can add. You should stop making payments on unsecured debt because the lenders will watch to see that. You should stop taking equity out of the business because the lenders will watch that. Basically, you should stop, overly oversized executive comp. You got to shut down on that. I think both Yael and Hartley said it before. You need to be transparent. You need to open a dialogue with your lender, and you need to basically commit to the loan. If you don't commit, then the lender won't commit. But if you're committed to the loan, most of the lenders will try and work with you, assuming you're not in retail, hospitality, or restaurant business right now. But you should be thinking about asking your lender for basically kind of additional dough and offering something else up, blocked accounts, kind of interest reserves, shorter end periods, assuming your cash flow can handle it.
No one will be surprised if a borrower goes to a lender and says, times are kind of tough right now. In fact, I think people would be surprised if you don't. But it all depends on what you're offering up. I mentioned some government changes earlier. One of the government changes on the loans, the borrowing side, had to do with banks paying dividends or paying bonuses. And so effectively government said, look, we'll open up the taps for you and we'll liberate more money into the loan system, but it's not going to shareholders as dividends. It's not going to executives as bonuses.
Right.
It's going into the market. And so to Eric's point, if you're entering into a discussion with a lender, being able to say, here's where the money is going. We need to borrow X dollars in order to keep the lights on or pay the 25% of our employees' wages not covered by the wage subsidy that Sari mentioned. Maybe we're going to expand something right now because frankly, we can find contractors, even if they're working 2 meters apart. If you can tell a good story and you're open and again, that word transparent with your lender, you're more likely to have a positive reaction because people know that a lot of these decisions about commercial relationships are made in good times, but solidified in bad times.
I like that one.
That's
Okay.
good.
Thanks.
Okay, let's look. Let's try and look forward a little bit. Obviously, there are all kinds of ramifications from what's going on. We really don't know at this point how things are going to work out. How many businesses are just going to fail, or how many will hang on by a thread and ultimately be able to come back. Any thoughts from your specific, your practice areas about how they may be changed as a result of what we're going through now? I mean, this is just a little bit of guesswork, but based on what you're seeing, based on, how lenders are looking at things, how the government's looking at things, how landlords are looking at things, how tenants are reacting, how employers are dealing with employees. Any thoughts about what changes we might start to see in the way our businesses are, our clients, work going forward? I'm just throwing that one out generally. Any thoughts from anybody?
Well, I'll start if you don't mind. I mean, I think I've been reading a lot, and I think it's pretty interesting in terms of office space and where things are going to go with that. We're all working from home now, and it's definitely a whole new experience for many. And while I think many of us are itching to get back to the office. I think there'll be a lot of discussions in the coming days and weeks and months ahead as we have to start going back into our normal or somewhat normal routines, and what the real estate space will look like in terms of the office. As you know, it's grown exponentially in Toronto, and there's also been a whole move towards densification of office space and open workspaces. And even once, and I mean, Sari, maybe your clients are also looking towards this as well. What does that space look like once we have to start going back to work or back into the physical office? There'll be probably new health protocols, government regulations, potential new code requirements, and how will that all play into, or sanitization requirements? There's so many different factors that are going to be coming into play. Maybe it's not a long-term thing, but it's definitely in the short term. Once restrictions start getting lifted, until there's a vaccine for the virus, I don't think, there'll definitely be additional requirements in order to have these buildings operable.
Yeah, so I agree, Yael. I think employers now are going to have to be a lot more nimble in terms of employees working remotely, using the hoteling concept a lot more frequently. In other words, employees not parking themselves permanently in a particular office, but only using it, on an as-need basis, but otherwise working remotely to save on significant rental costs and so on and so forth. For employers, though, really they're looking at the now, I think, more so as opposed to the future, only because there are so many subsidies and various government assistance that the government is rolling out as we speak. So there's the current CEWS, Canada Employee Wage Subsidy, that gives 75% of an employee's income up to $847 a week. So that's about a $58,000 annual income to employers who have experienced so 15% loss in revenue March of 2019 to March of 2020, and 30% loss in revenue for April and May compared to 2019. So they're looking at how to maintain their workforce now as much as they can with all of these government subsidies. I think the future right now is just so hard for anybody to grasp. They're not really ready to start looking at that seriously, and I think just hoping that business resumes as normal, but being as cautious as they can be. The occupational health and safety legislation really hasn't changed much. Before COVID, during and after, it always has been and will be that an employer is required to maintain a healthy and safe workplace for their employees. It's just what we do to maintain that healthy and safe workplace that employers will have to be a lot more diligent about in terms of disinfecting and temperature taking of employees who are coming to work and that sort of thing.
I have one last.
You want to go?
Go ahead. Eric, were you going to say something?
I just think behavior is sticky. I think that I don't think this is going to be kind of wholly transient. I think that people are going to rethink kind of education. Everyone's taking classes on Zoom now. I think people are going to rethink telecommunication, as Sari said, remote working. I think that just-in-time delivery is going to be out the window. People are going to start hoarding more. I can tell you right now that, 2 months from now, I'll still going to be looking for N95 masks for the next epidemic, right? I think since the systemic analysis of policies and procedures, I think will undergo kind of a radical change right now. You get caught short once, you don't want to get caught short again. So I think there's going to be kind of a long, hard look at the systems and policies and public policies that the government puts in place to protect the disenfranchised. Right now, you read the paper and there are all these stories about, people, acting out of their own, kind of their own heart for the greater good. But, COVID-19 has really, shown the highlight between the haves and the have-nots. It's very easy to shelter in place when you have a place to shelter. So, I think there's going to be kind of, public policy ramifications coming out of this, which none of us can see right now. But, I think that a reliance on kind of a global supply chain will decrease. I think people are going to become more localized. I think everyone's going to have a bug out bag. It's going to change behaviors.
In 2008, we said that would change everything. And we saw it didn't take a long time for people to revert back to their old habits. I do think it'll be a long time before people say TGIF again. But I think that on the individual side, behavior side, people are anxious to go do dry cleaning and go to restaurants. But I mean, we can't ignore the reality that this is not just a financial crisis, it's a health crisis that is causing a lot of pain and a lot of heartbreak for a lot of people in Toronto, in Ontario, in Canada, in the Jewish community, of course, and we need to be mindful of supporting each other. One of the best things that has come out of this is people calling each other just to say hi, just to check in. And I hope that while this is obviously a terrible event, I hope that we don't go back to the old habits of calling people once a year on their birthdays, that we actually have more check-in calls with our friends and our colleagues and our contacts just to say, hi, it's been a while, how you doing? That's one of the best things, and I hope that everyone who's sick can have a very speedy recovery and the curve gets flattened away.
Okay, great. Okay, we've run a few minutes over. We did say we'd finish at 5, so I want to thank very much all of the panelists who spent their own time putting together the questions, talking together to plan this. I hope the program has been interesting and useful to our participants. Couple of quick reminders. This program has been recorded, as was mentioned at the beginning, and there will be a link circulated to everyone. I'd also like to take the opportunity on behalf of the panelists to thank UJA for putting this together, for giving us an opportunity to speak together and to give us all together an opportunity to talk a little bit about what we've all been dealing with over the past little while. So thank you very much.